Hello Trinidad and Tobago, and welcome to another episode of Strictly Legal, hosted by yours truly, Rondell Donawa, and I am an attorney at law, and you are watching WESN Content Capital. Of course, you can stream us on www.wesncc.com or our social media pages, Facebook, Instagram at WESNCC. Right, so let's get directly into it. On the last episode, or the episode previously, we spoke about divorce and what about the children in divorce matters. However, one will ask, what about if persons are unmarried? What happens with respect if they have children? What do the courts do? Who is the jurisdiction? And how can they apply? And what sort of orders that the courts can give? Of course, we have magisterial proceedings and district court proceedings. And with me is a guest who she always tells me she loves magisterial matters, and she's very passionate about what she does as an advocate. And my guest is Ms. Donielle Jones. And just a little bit about Ms. Jones. She is involved in a well-rounded practice, mainly in criminal law, family law, and civil litigation, since being called to the bar in 2008. She absolutely, as I said, loves magistrates practice, and as such has done matters in magistrates courts throughout Trinidad and Tobago. She was recently appointed community lawyer at Wholeness and Justice, that's CAISO, in November 2020. And she is a volunteer attorney at the Coalition Against Domestic Violence, the Elmer Francois Legal Clinic, Romantra, and the Holy Trinity Roman Catholic Church Legal Aid Clinic, Aruka. And she's a proud South girl. She's from Penal. So welcome, Donielle.
Yes. Good morning.
Good morning.
Thanks for having me.
Thank you. And how are you?
I'm good.
Right. So you are a person who is well experienced in magisterial matters well as family court matters, along other things as we would have stated in your impressive CV. So we are speaking today about the magistrate system and custody, access, and maintenance. How can one access it? But first to begin, what is the role of the magistrates court in custody, maintenance, and access matters?
The magistrates court's role is the exact same role as the High Court. They both have the exact same jurisdiction, exact powers. There are only some limitations with respect to if there's a child is made a ward of the court, if there are divorce proceedings, or if there's a Section 46 application, if you are asking for the court to take a matter from the magistrates court. So that it's actually the welfare principle applies. What is in the best interest of children? It doesn't matter whether it's a child out of a marriage or a common law relation or a visiting relation. So they have the exact same powers.
And who can apply for custody? Let's start with custody. Who can apply for custody in the magistrate proceeding? Right.
So Section 13 of the Family Law Act says that any parent, biological parent, as well as anyone, a stranger, they refer to it as, so that anyone who in the court's opinion has that child's best interest. So that anyone who has a child could approach the court and apply for custody.
Right. So usually in magistrates matters, you find that persons who apply are mostly those who would have been unwed. Yes. Or who would have had a child for someone else and they broke up and then they want maintenance. You know, they always want maintenance and custody. Now, tell us what sort of orders that the magistrates courts can make in such proceedings.
Right. So firstly, when you make an application for maintenance, it must be accompanied by another application, which is either a paternity declaration, that is if the child's father's name is not on the birth certificate, or you apply for legal custody and maintenance. So they go hand in hand. So the court makes a paternity declaration together with a maintenance court order, and then it makes a legal custody order together with maintenance. And if the other parents wants access, it makes access orders, which should be visitation rights. And they also take everything into consideration with respect to how the parties are going to make this arrangement work in the best interest of the child.
And of course, at the end of the day, we also know that the welfare principle applies.
Yes.
Because as you practice, sometimes you find that persons don't understand, clients don't really understand the principle, and they believe that because you're no longer with me, you cannot see your child.
Yes.
And you touched on the legal custody. Now, I know in high court proceedings, the court can award joint custody. For the viewers, can a magistrates court award joint custody to parties?
No, the magistrate cannot award joint custody, and not even if the persons are unmarried, not even the high court cannot award joint custody. So if married persons approach the magistrates court for legal custody maintenance application, they could only award legal custody to one parent and access to the other.
Now, what happens to parental rights then? Because when one say they want legal custody, they think that they have the total control of the child in question.
That is untrue, because Section 18 of the said Family Law Act says that it preserves the other parent's rights. So your parental rights as far as other things, save and except the physical possession of the child living. So the one parent will have the child living with them and the other one will have a right to access, but that other parent will have all other rights to operate jointly with the parent who has legal custody. So say for instance, educational decision, medical decisions, travel abroad, religion, there must be some consultation. So I often tell my junior practitioners who associate with me that you must always request that right, because the main issue, parental alienation, is a serious thing, and a parent who has custody thinks that it's a pawn, so that they exclude the other parent.
And then judicial officers sometimes don't really explain or request whether or not one should retain their parental rights, and I think probably they leave that up to the attorneys to litigate on.
Exactly, and that too is a problem, because most of the persons who approach the magistrates court, most times they are unrepresented. So therefore the judicial officer ought to go down and explain to each parent what their role is now that you have custody, now that you have access, but I am going to preserve the parent who has access so that they could have some sort of discussion, whether it's by WhatsApp, email, phone communication. It doesn't have to be an in-person discussion, as well as the schools, the institution of the school, the teachers, the principal should also know that, because sometimes when a principal sees that one parent has that legal custody, I am only dealing with that one parent, and that's not how it's supposed to be. The principal should know that pursuant to that act, the law, it is that this parent has a right to know about his or her child.
But do you think that the legislation should possibly be amended to explain, or probably to rather be, I mean, for the layperson rather,
right,
to understand the concept of what is legal custody, what is visitation? Because as you said, when you order a transcript, all you see is legal custody and you see visitation. In terms of going down to what is parental rights, sometimes that line is blurred. So do you think that the law should be amended to sort of make the layperson more understanding?
Well, I think the law is clear, because when you read it, it's quite simple. But the difficulty I have is that the courts don't explain it, because when you have the opportunity to explain, you must explain it. So just as we as attorneys, when your client come, you explain to them what their rights are, the magistrate should do that. They should have more public awareness, that this is your right. These programs really will help members of the public for them to know their rights. And the members of the public, not only lawyers, should draw for their legislation. You print your legislation, go through it, and you are able to understand what your rights are.
And what are the factors that the court look at when awarding, let's say, custody to one party?
Right. So the main thing is, proper shelter, care for the child, which parent would allow access, which is a principle that not all courts take into consideration. Not because this parent comes to the court and they already have the child, mean that they automatically have the best interest. They have to look at the conduct of that parent. While you had custody, did you allow the other parent to get to know their child? And of course, it depends on what are the issues between the parties. So if there's an issue of sexual abuse allegation or child abuse allegation, of course that parent could provide supervised access or no access. But if it is that there's nothing wrong with the other parent, and then you keep that parent away from that child, the court, that is a red flag that the court ought to take into consideration and order a probation officer's report. So apart from that, the right to the child's education, how involved this parent is in terms of whether they live within the same jurisdiction or not, how long has the child resided with that parent. So those are and then to what the child's interest. Although children, what they come out to say, well, I want to be with mommy or daddy, they are more influential at a younger age. But from the time a child reaches like 13, 14, they are more impressionable and they can actually say why I want to stay with this parent or I want to go with the other parent.
And that is through the probation officer's report?
Yes.
And does the court hold weight on that probation officer's report to decide who gets custody, who is granted custody?
Well, it's a persuasion that, it is something that is ordered that will guide both attorneys, because as attorneys in custody matters, you are really an officer of the court, and to ensure that the child gets the best interest is really not for the mother or the father or any other guardian. It is really that where would this child best, achieve his best, so that if it is the court takes the probation officer's report, it is just a step to show, well, this is what an independent officer says about all the factors involved in this matter, and we should consider this. If not, you go to trial, and if need be, you can call the probation officer and cross-examine them on the report.
Yes. And let's go to maintenance. Now, maintenance, as I was said in a previous episode, that's the hot topic, right? Because you find that most times when persons apply for custody, which is mostly the mothers, that follows maintenance.
Yes.
Just explain what the court looks at in ordering maintenance and whether or not it has to be to the party that has legal custody versus the party that has access.
Yes, it must go with the parent who has legal custody, because that person is charged with the day-to-day responsibility, all the daily expenses also, so that it could be a collaboration. I have had matters where there's even though a legal custody order goes with a maintenance order automatically, right? The person has a right, once you have legal custody, to get financial support. But it doesn't always happen. But the court must give it to the person who has legal custody. But they will take into consideration the standard of living, the earning capacity, the manner in which the child is being educated, if the child has any disabilities, as well as the expenditure of both parents. So, most persons come to say, well, I'm working for this amount of money, but children have set financial needs that must be met: food, education, shelter, school transport. So those medical expenses, those are things that cannot be, you can't remove those things, so that back in the day your parents will join a susu. Yes. Your parent might pick up butters, yes, scrap iron dealer. Yes. So you have to find some way. So most people come and say, my fixed salary is this, but you really have to get your supplemental income. What else are you doing? And it's about earning capacity, not only a fixed salary. So I get laid off, I stayed home for 6 months. That don't make any sense. The child doesn't have an on and off button to say no food today, switch off. It doesn't have that.
And when you say earning capacity, because a lot of time persons may say, well, at least the fathers, well, I ain't working no way, I get laid off, I can't pay. What is the minimum? What is the minimum requirement?
Yes.
That the court or the minimum order that the court can make?
Well, it depends. Like each case depends on the earning capacity. Because if you have a gentleman with a limb missing, obviously he cannot go out into the job market and earn a salary that another gentleman with his both limbs. Yeah. So that the court really has to look at his earning capacity. What can a man with one arm? How much can he earn? Is he on disability grant? If he's on a disability grant, the child will automatically qualify for a grant from social welfare. So these are the things the court will look at. So if you're not working, say you were an engineer and then you get laid off, but you're getting a teaching job, which is half of your salary. You don't want that. You want to stay home. The court will look at that. The court will say he was earning $20,000. He's now earning $6,500. Well, I have to give him the variation of a decrease because this is what he's now earning. Yes. But he can't say that I'm just seated at home and doing nothing, so that I can't give anything towards my child, you know?
Donielle, let's take a break and we'll be right back. You're watching Strictly Legal on WESN. And welcome back to Strictly Legal on WESN Content Capital. You are watching a great show with Donielle Jones, attorney at law. So we are speaking about custody maintenance access orders in the Magistrates District Court. Donielle, before the break, during the break we were chatting. Now, there's someone who would have asked a question. They are living in they have dual nationality. That is the mother. She lives in the U.S. and she's Trinidadian citizen. She had a child with a Trinidadian national who's resident here, and but however the child was born in the United States. Now she wants to apply for maintenance, right, from the father who lives here, although the child is not born in Trinidad. Can this be done in local courts?
Yes, it can, and she is a national dual citizenship, so she is a national of Trinidad and Tobago, and it will be easier for her because the father resides here. So she can approach because the act says where the court that is in the district of either the applicant or the respondent, so that she can go to the district court where the father resides, and she can apply for maintenance there. And now there's court pay, so that there could be arrangements for the monies to be paid in a bank account. So I don't see why she can't.
And this is notwithstanding the fact that the child is not a Trinidad and Tobago citizen per se, because they would have been born in the United States.
It doesn't matter. Citizenship, it doesn't matter. They sometimes consider residence, but not for the purposes of applications relating to children.
Now let's walk the public through the procedure for applying for custody access maintenance order in the COVID period.
Yes.
Because of course, you know, the judiciary would have digitized.
Yes.
And with the advance of technology. So give an explanation as to what's the procedure and step.
Right. So some courts have that they have where you could attend the court office on making an appointment and you go there, or you can, the easiest method is via email. So you get the email for the particular jurisdiction that you're applying, whether it's a REMA, Grandi, Port of Spain, and you send an email. That's the mrcc.number, an email, and then you send your name, your address, your child's name, attach a copy of the child's birth certificate, the father's information or the mother's information, whoever is the respondent, your national ID, whether your passport, your DP, or your ID card, and you explain why that the child has been residing with you for a period of time and the father resides here and you would like to have a legal custody or maintenance, or if it's access that you want. Same email, someone from the court will then respond to your email and they will call you and they will take you through your application and then you'll get a court date.
But then what about persons who are not technologically advanced and they don't have email addresses? How will they get access to justice?
Well, some district courts, you can, as I say, call the court or visit the court. The guards will be able to assist. They will call out a customer service representative and they will take your information and then they will call you and they will guide you through. They'll take the information from you and the application is made. The same information, birth certificate of the child as well as your identification.
And where we know borders are closed, now for persons who are looking to make that application and they are not in Trinidad and Tobago, can they do that virtually from where they are living, if it's the United States or Australia or wherever?
Well, the borders closed. I haven't seen anyone who the court has said, no, you need to be physically here because of COVID, because the person cannot be physically here because of the borders closing. And I know of persons who have made it, but they have made it. An attorney would have sent the email on their behalf with the said documents, and they would have gotten the application listed because they are residing here and they have an address in Trinidad. And
with that being said, sometimes you may have persons who are not here, but they say that they're in Trinidad because they log in virtually, and you would have a clue which parts in the world they are.
Yes.
Now, I mean, you made the system sound so simple in terms of applying and applying for such orders. Now, there's a lot of issues that litigants face. Now, when it comes to the actual hearing, tell me some of the experiences that you face as a litigant in the Magistrates Court, particularly when a date is set and there's supposed to be service and nobody shows up.
Yes. So it first starts with the copy of the summons for service. That is a sore point for most litigants. When you get the summons, sometimes the officers are overworked in a particular station so that they wouldn't be able to serve it on time. So the other thing is that now with virtual applications is the processing of the summons. So the court staff, they're taking very long to send a copy to the litigant in order for it to be served. but they have now adopted a procedure where they are sending it directly to the police, which to me makes it even worse. I really think you should just email the summons electronically to the applicant, and the applicant can go to print it out, 2 copies, and take it to the police station and get it served. Because the volumes of summonses go into any particular station, I don't think it will be fair it is not fair for the officers with respect to service. And at court now, the issue is the volume of matters, because Port of Spain is the only core jurisdiction that enjoys a court that deals with family matters only. Every other court, it's a list in a particular court. So it's the lesser criminal matters together with the traffic list, together with the domestic violence list, together with the family law list. Yes. For example, Superior only has 2 courts. For example, Sandy Grande, 2 courts. So that is another thing that they need to do, really assign, right? And the other issue is poor management of some judicial officers. And I want to say this candidly.
And when we say judicial officers, we mean magistrates or district court judges, right?
I really think that some of them, very few, not proper time management as well as general management of the courts.
Yes.
And then you have the issues with attorneys. So people like to frown upon magistrates court. I'm at high court, I can't go to magistrates court. And a lot of magistrates allow that. But at the end of the day, a magistrates court ought to have the said respect as the high court. So yes, they could get allowances. You have a matter at the magistrates court, but at the high court, but the magistrate court can't wait indefinitely to do this maintenance matter that a child needs money to go to school. So you will give a certain grace period and then you set the matter for trial, right?
And don't you think that judicial officers need to be more aware of what parties are applying for in terms of the humanistic side? Because, like, for instance, in Superior Court proceedings, I would have applied for access. My client would have applied for access, and he hasn't seen his children since last year. The police never served the summons, and the magistrate decides to give a June date until July. And obviously, I had to explain to the magistrate that, listen, time is of the essence.
Yeah.
So do you think that judicial officers are not aware of the urgency sometimes of some parties?
Well,
issues?
Most of them, they are aware, but some of them don't care to fix it, and others try their very best. Like, for instance, Superior, I find that volume of matters there is very difficult for any judicial office magistrate to deal with that court. But at the end of the day, and then you need to develop some system for the services of summons. I know at Superior, they actually call the summons officer, go to the station and talk to this officer, his number is so by so, and that's how they get summonses served in some courts, right? So that
or you have to request that the sergeant in charge or the particular person who's there do it.
Yeah, so that's the problem. But if we had a court, right, that is designated for family matters, and the court doesn't have to take away time to deal with the traffic list, or the DV list, you think that matters will move quickly along,
But do you think that the court is fair when it comes to judgments, especially when you represent the male? And do you think the court is really fair?
Well, I have experienced both sides, right? In terms of, I've seen magistrates who are pro-women, I've seen magistrates who are pro-men. Most times they are pro-women, and they are magistrates who are really equitable creatures, right? So that, yes, I see the bias at times, and especially, and bias could depend on your sex, your economic background, your job, the way you dress, the way you speak. If someone is not able to explain themselves, some magistrates may dismiss a litigant, but court is an intimidating place.
But then you also have the issue where the judicial officers, they will be opinionated, right? And not weighing on what is the evidence before them, and rather watch somebody, whether they have 4 children, and decide, well, why you have 4 children, 4 different child fathers, and why you want maintenance on all of them.
Yes.
And not look at the law.
Yes.
And that is something that, do you think that the system needs to be improved, or how can the system be improved
The system ought to be improved because your personal experience or your personal opinions or religious opinions or beliefs ought not to find its way at in the courts, because the court is a place of justice, which fairness must prevail. So if a woman has 4 children, 4 different men, each one of the fathers are responsible for his or his child. So therefore, she is entitled to come 4 times to the court to get her without any scrutiny. It is not a court of morality. It is not whether how many children she have out of wedlock, you know, so, and it's not whether if this man has 4 wives. It's not your business. Those things are not your business, and it ought not to find a way. There's a child, the woman wants a maintenance order, or the man wants custody of his child and mental. Deal with the facts in the particular, but don't tell me about the case yesterday, a man gave vex, you see a man appear today, you vex, oh, another slacker. No, it can't be like that. Each case must be determined on its own facts and merits.
And what reliefs can somebody apply for if they feel unfairly judged by a magistrate?
Right. So there are a number of things they could do. So if it's just like on the first day you felt badly, and the second day the magistrate addressed or made a comment that, you know, didn't sit well with you, you can ask the court, or your counsel could ask the court about it and point the court to the law to say that it ought to be fair. And then you monitor the situation. And if it's not getting better, you can file a procedural appeal. You can ask the court to recuse itself and have the matter transferred to another court. If you could do judicial review of it, but you know the candle will cost more than the funeral. So you know, it's all about is a judgment call.
Litigants who don't really have the means.
Yes.
And then the another issue is legal aid.
Yes.
Right? I mean, everyone is entitled to legal aid once you meet the threshold.
Yes.
However, is the system of legal aid working, especially for persons who require it in magisterial proceedings?
Legal aid, I must say, has done its part. So, however, the applicants, and given the prevailing financial and economic crisis now, of course, they will have to provide more. So there's a need for more officers and you know, creative ways of getting to the applicant, you know. So definitely there's a need for more legal aid attorneys and availability for legal aid advice and those sorts of things. But at the end of the day, and then legal aid doesn't do certain matters, like judicial review. So even a magistrate, you know, you really have to go and see if you'll get an attorney who will do it for you.
Have you ever had a situation where you had to ask a magistrate to recuse themselves?
Yes, I have.
Have they recused themselves?
One did. After I pointed him to his comments, he did.
Right.
Yes.
You know, sometimes it can be a tug of war.
It is a tug, and then
I know you're outspoken as well.
And you may not be able to go back to that court for 2 years, which happened to me.
Wow.
Right. So that I had to, because again, if they see me, my client wouldn't get justice because of the fact of what I would have told. He's personally offended by my statements, but it's not a personal thing. It's about me just getting justice for my client.
For your client, and it's about the law.
The law.
And you. The law matters.
Yes.
All right, Donielle, I know it was short, but we are out of time.
No problem.
And I want to thank you for agreeing to come on the program to impart of your knowledge and your passion, right, for justice in Trinidad and Tobago. Of course, I will call on you at another point in time to discuss something else if you are free.
Yes,
all right,
I'm available.
Thanks again. So, guys, you are watching Strictly Legal with yours truly. We were speaking about the magisterial courts and how can one apply for custody, access, and maintenance of the magistrates' court, as well as what can be done to improve the system. Catch us at another episode. You are watching WESN Content Capital. Goodbye.